Murder, rape, and terrorism, the most severe offenses in the legal system, fall exclusively under the jurisdiction of a sessions trial. Historically, these cases have carried the heaviest stakes, but often moved at the slowest pace. The Bharatiya Nagarika Suraksha Sanhita, or BNSS 2023, restructures this process. Specifically, Chapter 19, spanning sections 248 through 260, provides the exact procedural blueprint for trying these severe cases. The primary objective here is to eliminate the pre-trial limbo that characterized the older system. The new code is designed to force forward momentum through specific statutory deadlines. To achieve this, the BNSS trial pipeline is built on three foundational pillars: strict statutory time limits, the mandatory integration of audio-video electronic means for recording evidence, and complete procedural digitization. The tension running through this entire pipeline is a delicate balancing act. The state requires a mechanism for rapid conviction, while the accused retains an absolute right to a fair defense. This balancing act is a constitutional mandate. In the landmark Maneka Gandhi case, the Supreme Court established that any procedure stripping a person of life or liberty under Article 21 must be fair, just, and reasonable. Later, in Husainara Khatun, the court explicitly recognized that a speedy trial is a fundamental right embedded directly within that same article. Sections 248 to 260 of the BNSS take those broad constitutional guarantees and apply them mathematically. They force the administration of criminal justice onto a rigid stopwatch. Section 248 dictates a public prosecutor conducts every sessions trial. As officers of justice, their mandate is finding the truth. The Supreme Court ruled in Shiv Kumar v. Hukam Chand that prosecutors must present evidence objectively, expressly forbidden from suppressing facts favoring the accused. Once the accused appears in court after being committed, the trial formally begins under Section 249, where the prosecutor opens the case. This opening requires three specific tasks. They must describe the charges, explain the nature of the allegations, and clearly state the proposed evidence. This step establishes the complete foundational blueprint of the trial. By requiring this total disclosure up front, Section 249 prevents surprise tactics. It locks the state into a defined narrative from day one, allowing the defense to see exactly what legal battles will be scrutinized in the highest courts. Immediately following the opening of the case, the BNSS introduces its first major time-bound mechanism. Under Section 250, the accused has the right to file an application for discharge within 60 days from that commitment. The judge's task at this stage is highly specific, looking solely for a prima facie case, determining only if there is sufficient ground to proceed. The Supreme Court clarified in Union of India v. Prafulla Kumar Samal that if the evidence raises only mere suspicion and two distinct views are possible, the judge is required to discharge the accused. However, as ruled in Sajan Kumar v. CBI, the court cannot conduct a mini-trial at the discharge stage. A meticulous deep dive evaluation of the evidence is forbidden during this phase. If sufficient grounds exist, the process diverges to Section 251. Cases not exclusively triable by a sessions court are transferred to a magistrate. For exclusive sessions cases, a strict deadline applies. The charge must be framed within 60 days of the first hearing. The code also mandates digital flexibility at this juncture. The charge can be read and explained physically in the courtroom or remotely through audio-video means. This 60-day wide junction acts as a procedural bottleneck breaker. It forces the court to either definitively release the accused or officially commit to a trial. Once the charge is framed, Section 252 allows the court to immediately convict if the accused unequivocally and voluntarily pleads guilty. If the accused claims trial, the court moves to Section 254, the recording of prosecution evidence. This is where the BNSS integrates modern recording standards. Witness testimonies and evidence can now be recorded entirely through audio-video electronic means. This specifically targets the depositions of public servants, a factor that historically caused massive scheduling delays, allowing their testimony to be integrated digitally to keep the trial moving. The judge can permit deferred cross-examination. As noted in State of Kerala versus A. Rashid, this ensures the defense is never prejudiced by witness scheduling. The integrity of this phase is reinforced by the witness protection scheme, validated in the Mahendra-Chawla case, which ensures that whether a witness appears physically or digitally, the environment remains free from intimidation. After the prosecution rests, Section 255 acts as a failsafe. If the judge finds no evidence connecting the accused to the offense, they must immediately halt the trial and record an order of acquittal. If the trial survives, the burden shifts. Under Section 256, the accused is called upon to enter their defense. The defense uses oral evidence, written statements, and the power to summon documents or witnesses to respond to the state's case. In Natasha Singh, the Supreme Court clarified the right to lead defense evidence is the mechanism enforcing the presumption of innocence throughout the trial. Sections 254 through 256 integrate digital evidence recording directly into the trial process, removing the reliance on physical document transit and manual transcription. The trial enters its final phase with Section 257, where both the prosecution and the defense present their final arguments, summing up the accumulated evidence. This triggers the most aggressive timeline reform in the entire BNSS under Section 258. Judgment must be pronounced strictly within 30 days from the completion of arguments, extendable to a maximum of 45 days only if the judge records specific reasons. If the judgment results in a conviction, Section 258 mandates a separate, subsequent hearing on the sentence. This separation gives the defense a dedicated space to introduce mitigating factors and allows the court to consider a reformative approach to sentencing. This hearing serves as a critical filter, applying doctrines like the rarest of rare standard established in Bachchan Singh before imposing the death penalty. To protect the integrity of this outcome, Section 259 acts as a final safeguard. Evidence of any previous conviction cannot be disclosed until after the current conviction is handed down, preventing judicial bias during the trial itself. Finally, Section 260 provides special procedures, such as holding proceedings in camera, for sensitive cases involving defamation against high constitutional authorities. By combining these provisions, Chapter 19 of the BNSS removes the ambiguity of time, hardwires technology directly into the courtroom, and structurally guarantees the fairness promised by Article 21. By codifying 30-day judgment deadlines and 60-day framing limits, the BNSS replaces judicial discretion with a mandatory schedule for accountability.